on the record in the matter of the State of Michigan versus Jason Attard, 24275.
Good morning again, Your Honor. Arthur Brand, P11126, appearing on behalf of Jason Attard, who's seated to my left.
Okay, Mr. Attard, your name for the record, please.
Jason Attard.
All right, and so today's date scheduled for sentencing on Mr. Attard's amended charge of improper possession of a firearm while under the influence and operating while intoxicated, visibly impaired and open intox. And counsel, did you have an opportunity to review the report and recommendation with your client?
I did, and let me just indicate in the beginning, my client was not charged, convicted, or anything else having anything to do with a weapon, or at least a gun. If that's what the court said, he pled guilty to improper transit of these brass knuckles that he happened to have with him, but there was no gun or anything of that nature. He pled guilty.
Before we continue, let me just look at this, because I was not the judge that accepted the plea. So my first question, counsel, do you have any objection to this court continuing with sentencing, although a visiting judge accepted the plea? Is there any issue with that?
No, of course not.
Okay. And then I'm showing that the charge that was charged was possession of dangerous weapon. And yes, it was metallic knuckles. I'm also assuming that this is improper transport of a dangerous weapon.
That's correct. That's what he pled to as far as that count was concerned. And of course, the original count was dismissed.
Well, okay, well, let me just, because what I'm showing is improper possession of firearm in or upon motor vehicle.
Well, it's not what he pled to, Judge. I remember we did have a visiting judge, Judge Kalmbach, and I believe it was Judge Kalmbach, and I was there. I'm an officer of the court. I can tell the court that he pled guilty to exactly what I said, which was improper transit.
Counsel, I'm going to take a brief recess. I just want to see if maybe it just got dispelled wrong. I just want to make sure we're all on the same page before we proceed with sentencing, because that could have an impact, okay? Jason Attard, we're recalling that. And I'm recalling it, counsel, because I just like it to be on the record. There was some extensive research into this, and there apparently is not a statute specifically for transporting or possessing brass knuckles or even a non-firearm weapon transport. And I say that because it appears as though the plea was for improper transport of a dangerous weapon. However, it appears also that MCL 750.227D is what was, I guess, pled to, but there isn't anything within the statute that addresses anything other than a firearm.
Okay, well, we did not plead to a firearm, and my client did not have a firearm.
Right, I'm aware of that, counsel, and so I'm really curious as to how, well, so it said no contest, because that would explain how the factual basis ended up occurring, because I thought, okay, if there's no weapon, no firearm, how is the factual basis obtained? And the no contest would be reviewing the report. But again, there's not a firearm, and there's not a statute that says improper transport of a dangerous weapon. It's transporting or possessing firearm in or upon motor vehicle or self-propelled vehicle designed for land travel. Now, if counsel, you're aware of the statute that addresses specifically that, then okay, we can do that. But I think in any event, I don't believe we should proceed with sentencing today, because it doesn't appear as though that the plea has been perfected in the matter that there is not a firearm that this matter could have been reduced to improper possession of a firearm or improper transport of a firearm.
Well, the only thing I can say, Judge, is it was represented to me by the prosecutor that they were offering a plea to improper transit. And if no firearm was ever mentioned, I did not check the statute because I wasn't given a statute number when we pled, when we walked into court that day. And and that was the only representation made to me. But
because I can understand and appreciate that. That's why it's always most helpful so that everybody's on the same page. If when there's an amendment to specifically a felony being reduced to a misdemeanor, that the statute gets placed on the record, or that the statute number itself is discussed between counsel so that there is an understanding of that. So what I'm going to do, counsel, is I'm going to not proceed with the sentencing based upon that. So if you'd like, I can set it for a review/hearing on a Thursday where Mr. Shastra is present, so that the two of you can readdress this matter regarding the plea to make sure that there is an accurate plea.
can I have the statute number again, Judge?
MCL 750.227D.
257D?
750.227D as in David. So what I'm going to do, counsel, is I'm going to adjourn for hearing regarding plea. We'll put it for August 8th. And I'm hoping that that's not a week that Mr. Shastra is in training. So just please keep an eye out on your email in case that date does not work. I would just encourage you to reach out to Mr. Shastra before August 8th so that the two of you can, do your legal mind thing and try to come up with another alternative, or if that's what ends up happening, okay?
Okay, Judge. Thank you.
The binding conditions are continued.
Yep. Okay. Go! Will you hand me my screen box?
Now go.
In the matter of American House Riverview versus Kristen Swerlick, 2401121. And counsel, your appearance, please.
Good morning again, Your Honor. Michael Kern on behalf of American House Riverview.
Thank you. And ma'am, your name for the record, please.
Mrs. Kristen Swerlick.
All right, thank you. And Ms. Swerlick was here in person. Again, I apologize, ma'am. I was unaware that you were here in person.
Okay.
But in any event, you were able to go into an office and there was a breakout room where you were able to speak with Mr. Kern, correct?
Yes.
All right. And counsel, you ended up then indicating that you got kicked out or you lost service with your connection, and so you logged back in with a different device, correct?
That's correct.
Okay. And you also indicated that there was not a resolution at this time.
That's correct, Your Honor. Ms. Swerlick does not dispute the balance that she owes, but has indicated to me that she does not have the money to pay it at this time. She said she's trying to work on some a pension issue with her deceased husband's pension, but at this point in time, she doesn't know how much money that is, and her income doesn't cover her monthly rent. So I suggested we work towards a resolution for her to move out. She was not agreeable to that.
Okay. Ma'am, did you want to respond to that?
I can't imagine moving.
All right, counsel, I'm not sure what happened, but somehow we got muted. So Mr. Kern, Ms. Swerlick is stating that she doesn't have any money, she doesn't know where she would go. Ms. Swerlick, I would suggest you contact somebody with some legal assistance, or even look into some rental assistance, because I can appreciate your situation, ma'am. However, that's not the responsibility of American House to supplement your rental, your rent.
Well, see, I thought, Your Honor, I thought that the lady that was in charge of relationships there, She moved on to a different job now, and she was gonna help me when I moved. She told me it would be way less than what I paid. I never agreed to pay all that. She told me it would be way less. She said I would qualify for many discounts.
Okay,
And then we never did anything, because I was ill a lot, so I didn't ask her. And I didn't realize I was paying it. I didn't know how to read the billing. I didn't see the fine print at all. I never knew it was going out. I thought I was waiting for her to help me still.
okay,
So it was all a misunderstanding, deep
okay. Well,
misunderstanding.
ma'am, if you wouldn't have moved in with that price, then you're going to have to potentially look somewhere different for a place to live. If there's not a resolution between
Well,
you and American House
Yes.
for a different amount, I'm not sure. So that's something that you and Mr. Kern will have to chat about. And Mr. Kern, I don't know if there's something you need to speak to your client about regarding potentially a different price that was agreed on, I don't know. But we'll set this for a second hearing on August 9th. You have anything else?
Well, I was trying to, I had planned to call Chrysler, I was ready and set to do it. And that's when the disturbance started at American House on my floor, the second floor.
What is? you were
Tremendous
set- you were-
disturbance.
I'm sorry, you were set to do what, ma'am?
Call, my husband called Chrysler and asked him for my pension from my husband.
Okay.
I started getting a couple checks when he died six years ago, and I didn't cash them due to illness and COVID and everything. And then I never did, they stopped giving them to me, saying silly things like, we hear you're divorced, and my husband was dead, and they were sending me notices, you're divorced, so we're cutting you off. It made no sense to me. And through it all, I just gave up on them for a while. I forgot about them because I was very, very ill. So I just forgot about them. Because I had a life insurance to live on, and it ran out while I was at American House.
Okay,
That's what caused all this.
okay, and I can appreciate all that, ma'am. So hopefully there can be some resolution, you have something from Chrysler or whatnot.
Yes.
By August 9th, or you're contacting somebody regarding rental assistance or whatnot, but we'll see you all back on August 9th at 9:15 a.m. All right,
And then if I could just say to Ms. Swearlick, my phone number is on the paperwork that you received for this case. If you would like to give me a call to discuss this some more after you've had a chance to talk to Chrysler, I'm happy to do that.
Okay, okay.
all right, and then we'll see you all back on August 9th at 9:15 a.m.
Okay, thank you, Judge.
Thank you. Thank you, have a good day.
Mr. Money.
Okay. And so we are moving on the record in the matter of the state of Michigan versus Braden Throwfall, 241074. And Detective, your name for the record, please.
Morning, Your Honor. Detective Joseph Carr, Wyandotte Police Department.
Detective, you may proceed on the warrant.
Your Honor, July 28th, about 3 a.m., Officer Adam Grote reported he observed a black Dodge Durango in the area of 4th Street and Davis. Officer Grote reported the vehicle was observed heavily swerving, nearly striking a curb, and traveling at a reckless speed with estimated speeds of in excess of 70 miles an hour. Officer Grote was able to catch up to the vehicle where a traffic stop was initiated in the area of 4th Street and LeBlanc in Lincoln Park. Officer Grote then made contact with the driver, later identified as defendant Braden Throwfall. Officer Grote reported that upon his initial contact with the defendant, he detected a strong odor of intoxicants coming from him, in addition to what appeared to be powder or crack cocaine on the center console, the front seat passenger seat, and on the defendant himself. The defendant was asked to submit to a series of standard field sobriety tests, at which time he failed. The defendant was also submitted to a preliminary breath test with a result of 0.17 BAC. The defendant was then advised he was under arrest for OWI, where he was cuffed and detained in a rear patrol car. During an inventory search of the vehicle, officers recovered a small glass jar containing the suspected cocaine, where it was field tested with a positive result as being cocaine. Officers also discovered an open container of whiskey under the driver's seat of the vehicle. Per Lean SOS, the defendant has a prior alcohol conviction in 2021, And once at the station, defendant agreed to a breath test with a BAC result of 0.21 at 4:09 a.m.
All right, upon examination of pleading witness, I find that crime was committed, probable cause exists that to believe defendant committed the offenses. And counsel, good morning, your appearance, please.
Good morning, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Thrillfall. At this time, Judge, we are prepared to waive a formal reading. My client stands needed.
Thank you. And Mr. Throwfall, your name for the record, please.
Braden Throwfall, Braden Richard Throwfall.
Counsel, you said this, you were going to waive the formal reading?
That's correct, Your Honor.
Okay. The court will waive the formal reading. You understand that you do have the right to have an attorney, and if you cannot afford one, the court will appoint one to represent you. Do you understand that?
Yeah, yes, Your Honor.
The court's going to enter plea of not guilty to EF, schedule this matter for probable cause conference on August 8th. 9:15. At 9:15 a.m. Okay, and
Yes, Your Honor. I would like to know that Mr. Thrillfall currently is employed at Taylor. He's not currently on probation or parole. After speaking with him at length this morning, he did assure me he would be appearing at all future court dates. He's never failed to appear for any reason whatsoever in court. Judge, I would like you to know he does have one prior drinking and driving offense. Judge, I'd ask that all that be taken into account when assessing a bond on behalf of my client. In addition, he is gainfully employed. However, between his bills and his child support payments, he has somewhat fallen on hard times at this time.
all right. Well, so Mr. Throwfall, you've been working at the restaurant.
I've been there for around 2.5 years, Your Honor.
If you were to test today, what's in your system?
If I was tested today,
Yes.
marijuana and cocaine, I would say.
Okay. And do you have a valid prescription for marijuana, sir?
No, I had a card a while ago and I just never renewed it. I just haven't had the need to because it's recreationally legal, so.
Okay. And are you out on bond in any other jurisdiction?
No, ma'am. I mean, no, Your Honor. My apologies.
You're on probation or parole, correct?
No, Your Honor.
Okay. And Detective, would you like to address bond?
Your Honor, just to consider the nature of the offense reported, I'd recommend a $1,000 cash bond. And if the court would address some type of a monitoring device regarding the defendant's alcohol consumption, Your Honor.
And sir, you pay child support, you stated. How old's your child?
My daughter is 6.
Okay. And so that's paid through the court? There's a court order for that, sir?
Yes.
Okay. And you have regular parenting time with your child?
Yeah, it's every Sunday, but it's amenable depending on what she asks for. So if she's okay with it, I'll take her sometimes from Monday to Thursday, sometimes from just Sunday to Monday. It's amenable by our own agreement, Your Honor.
Does your limited parenting time have anything to do with any alcohol or substance use, sir?
Me living with my parents, does that have anything to do with it?
Does the limited time you have with your child have anything to do with any potential treatment that you should probably be seeking or no?
No, I wouldn't say so. Like, are you saying that the amount that I see my daughter is? I don't quite understand the question, if you want me to be honest.
Okay, I'm just wondering, sir, if you've had a history of alcohol or substance use, and that's one of the reasons why you have limited parenting time.
No, I have limited parenting time because of the other parent question.
Because of what?
The other parent in question.
Oh, okay. All right, so here's what the court's going to do. Based upon the nature of the charges, based upon the court wanting to protect the safety of the public and ensuring that Mr. Thrallfall is going to be returning to court and complying with this court's conditions of bond, this court's going to order a $10,000 10% bond alcohol tether, which, sir, I will allow you to obtain through EMS tether, but you don't leave without having that tether, okay? So that means that they'll come here. It's an additional, I think, $190 that would have to be paid in addition to your bond.
Upfront?
Yes, upfront. The court's going to also order that you are to participate in random testing and that you're not to possess or consume any alcohol or drugs that are not prescribed. So while I understand that marijuana is recreational, so is alcohol. You cannot use either of those, sir, without a valid prescription. And clearly,
Understood.
any other controlled substance you can't use anyway. All right. Well, actually, any other illegal substance you cannot use anyway. Any controlled substance you cannot use without a valid prescription. Okay? Any questions?
No, thank you, Your Honor.
All right,
Thank you,
you. All right, have a good day. All right, and we are on the record in the matter of the city of Wyandotte versus Christopher Magyar, 241075. And counsel, your appearance, please.
Attorney Corey Westmoreland, appearing on behalf of Mr. Magyar. Mr. Magyar, would you please state your full name for the record?
Christopher David Magyar.
Okay, and so counsel, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
All right, the court will read the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for pre-trial on August 7th, and counsel as to this matter.
Yes, Your Honor. I would like to know that my client is currently residing in Taylor with his mother. He's currently unemployed, but he is actively looking and trying to pursue employment at this time. He's not currently on probation or parole. And after speaking with him, he did assure me he would be appearing at all future court dates. I would just ask that all that be taken into account when assessing a bond on behalf of my client.
Okay, and sir, why don't you work?
Well, I actually, this past 2 weeks, I stopped working. I was a roofer, and my boss, his workman's comp is his insurance lapsed. So I'm waiting for him to either reinstate his insurance so that we can get our jobs coming through, or and if he don't have something for me within the next week, I'm just gonna find something else. But it's just been this last 10 days I haven't worked.
And sir, you're not on probation or parole for anything else?
No.
You have a significant criminal history, sir.
Yes, Your Honor, I do understand that, Your Honor. I mean, I've been doing good ever since, I came home, and this time it just got out of order. I got in an argument with my old lady, and I raised my voice a little bit too much. My voice is deep, so it travels.
Pause. Got home from where?
Can you repeat that?
You stated you have not been getting in trouble since you've been home. Been home from where? Where did you go?
The Michigan Department of Corrections.
Okay, and so how long were you in custody, sir?
I was in custody for a little over 3 years, and I came home in 2019, and I've been home for about a good 4 or 5 years. I haven't had no issues.
Okay.
No, you know what I mean?
Hold on. You mentioned you got in a disagreement with your old lady. What does that mean, old lady? Who's that?
I apologize. I got in a verbal argument with my girlfriend who I'm living with, and we started. My voice is deep, so I started yelling, and the neighbors called the police. So that's why I got the disorderly. You know what I mean? And honestly, I understand, that things happen, and I apologize, but honestly, I think that I'm here over something that was misunderstood.
Well, sir, in reviewing the allegations in the report, it doesn't look as though it was a short misunderstanding. If you were to test today, sir, what's in your system?
I wouldn't even know, honestly.
Okay. Well, what would you suspect would show up in your system?
Marijuana,
Anything else, sir?
maybe some methamphetamines, and that might be it. But that's not that I could be clean for that too, because I haven't used in a while.
Are you on bond in any other jurisdiction, sir?
Oh, no, Your Honor.
All right. Based upon the nature of the allegations, taking into account your criminal history and the nature of the charges here. And in order to make sure that the bond conditions are complied with and that you are not a threat to society, the court's going to order a $5,000 10% bond with the following bond conditions. You not to have any contact with Ms. Borgowski, that's phone contact, text message, email, social media, third party, anything of the like. You're not to return to the home on, with the exception of obtaining personal belongings accompanied by a police officer on one visit. You're not to possess and consume any alcohol or drugs that are not prescribed. And then we'll see you back on August 7th, sir. Have a good day.
All right, we're going to go on the record. Court is calling 2020 CR 11865, State of Texas versus Mary Jessie Diaz. Can I have parties announced for the record for the state?
Alan Jackson for the state.
Defense?
Charles Buck and Jim Tochi for Ms. Diaz.
And are you Ms. Diaz?
Yes, Your Honor.
You entered a plea of no contest on July 16th to the offense of murder. According to the plea bargain agreement, punishment is to be assessed at a cap of 25 years in the prison. There are no applications, and of course, for murder, you're not eligible for probation. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Judge.
Any objections to the PSI report?
Not from the state, Your Honor.
No objections, Judge.
All right. Any witnesses from the state or the defense?
Not from the state, Your Honor. We just have argument.
No witnesses, Judge.
All right. Then the court will hear argument. State, I'm
Yes.
assuming you're requesting that I hit the cap?
Yes, Your Honor. We feel that the 25 is already taking kind of evidence and other things into consideration. But especially after, if you read the PSI and you've had a chance to review the report, to review the autopsy, there's just several things I want to highlight. Not only did Ms. Diaz shoot Christopher Jones in the back, she left him to rot, Your Honor. She left him alone in that house for the better part of a month. And there's evidence that she returned at least once, but likely more. She took his phone, his wallet, his watch, his dog, and his car. She used his car, she drove it around, she spent his money, she racked up his calls, she tried to collect rent from one of his friends, she tried to sell his equipment, and in that event, she got the murder weapon stolen. She not only tried to convince his family and friends that he was still alive through her texting them on his cell phone, she also tried to convince the police he was still alive. She impacted his entire family, his mother, his sister, and his aunt, and the children that he had only recently connected with. And so 25 to us is the only thing that even came close to getting any sort of justice, Your Honor.
All right. Defense.
Hey, Judge. Excuse me, on behalf of Ms. Diaz, we believe the PSI does discuss quite a few things that I would ask the court to consider. First, regarding the PSI, it talks about her children, and it says she has 4. She actually has 6, just so the court knows. Factually, there are some inaccuracies in the PSI. She has 6 children rather than 4. It does discuss also some things that happened to Ms. Diaz as she grew up and some of the difficult things she faced as a young person. Now, addressing what happened on this day, and the state talks about the fact that the 25 takes into account all the factors that led up to what happened on this day, and perhaps it takes into account some of it, but Ms. Diaz, in her description of what happened that day, you know, she comes clean and she tells the court exactly what happens that day, and she's correct and she's truthful with the court in the PSI. And one of the things I think the court, you know, the state wants you to believe that she just left in there and did nothing regarding the police, but in fact, she tells the court through the PSI that she thought the police had been notified through these people, because she goes immediately and tells somebody what happened. And she tells through the PSI, she says, I thought the police had been notified. And if you read the stipulations, you'll see that in fact, the police were notified. The police were called and told, and they did nothing about it. while Mary did not call the police, she told people what happened, and those people called the police and told the police. And then for whatever reason, the police didn't believe anything about it. And so I think it was Vanessa and her roommate or her wife, or whoever it was, when they called the police, for whatever reason, nothing happened. Now, the problem that Mary then ran into is as time passed, it just kind of, it became more and more difficult, and it's kind of snowballed on Mary. And certainly she should have come forward, and she didn't. And she realizes, as she stands here today before the court, she realizes she certainly should have come clean. But as time passed, it became more and more difficult, and she made bad decision after bad decision after bad decision, which led her to make the one decision that, that perhaps was her one good decision, that was to accept responsibility and come before this honorable court today and say, Judge, I'm here. I accept responsibility. You can see I don't think you've seen a PSI that is as accepting of responsibility as this one is. She tells you exactly what happened. She tells you why it happened. She tells you what was going on between the two of them and everything. And the good thing, if there is any good thing from Mary's version, is it's completely supported by the stipulated evidence. All the trouble that she says they were going through together is supported by the stipulated evidence. The fact that she tried to do something right after it happened and the first aid she tried to administer is supported by the stipulated evidence. So as she stands before you, she is accepting responsibility. She understands the court has to make this decision. She wants the court to know that she understands she's hurt many people. She's made a community feel unsafe. She's caused so much emotional stress to all the people that know about the case. She's done things. She's hurt his family. She's hurt her family. She's hurt everyone touched by this. But she can't change that. She's by accepting responsibility, she's hoping people will see that she's doing everything she can to make it right, even though it's years too late. And then when we talk about years, in this case, we're talking about a cap of 25 years. And the court, has the ability to consider, obviously a cap of 25 means 5 to 25. And we're certainly not thinking by any stretch the court should consider anything between 5 and 25. The court shouldn't. This is a murder case. This is the taking of someone's life. But we're asking the court to perhaps consider something between 20 and 25 years. And I would ask that the court read the stipulated evidence. I would compare it to her statement of the facts. I would also ask the court to consider the fact that she spent 1 year in jail and then 3 years on full house arrest. She didn't ask to go work. She didn't ask.
So what does she mean if you turn to page 11?
Yes, I was going to get to that part.
All right, if you can
You're
tell me
talking about
what
the
she
fair
means.
part?
Yes.
Yeah. So when she was asked about that, I asked her about that. I said, Mary, this sounds terrible. And she says, Charles, what I was trying to say was when this happened, he had been, our situation, his and hers, was a volatile, abusive situation. And I had to make a decision on what to do, how to react. And I reacted in a way that turns out I had to make a decision that at the end wasn't fair to me. And in other words, she doesn't mean that this isn't fair. She means the result, she made a decision that in the end, the result wasn't fair to her, and that she was placed in a situation where she had to make a decision that it wasn't fair to make her make that decision. In other words, he placed her in the untenable situation where you've got to decide to make this decision. And it's not fair to put a person in a situation where you've got to choose either I'm going to do something terrible to you, or you have to do something terrible to me to keep that from happening to you. And that's not a fair decision to put another person in. And that's what she meant. She certainly does not mean that it's not fair that she's before this honorable court. So, and because I asked her about that, I've cringed just like I'm sure you did when you read that. But that she's not inferring or not telling this honorable court that it's not fair that she's here. It's certainly fair. She's here. And if it wasn't fair, we wouldn't be here. We'd be in trouble. Certainly, Mr. Coach and myself, if we didn't think it was fair, we wouldn't have pled. we wouldn't be here. She understands, she accepts. What she meant was it's not fair to put in a person in a position to have to make that choice. Hey, am I gonna have to hurt you? Are you gonna hurt me? And that's not fair to make a human make that decision. That's what she was trying to say on that day, not to you, but to Chris. And so it was just an unfair position to put another person in. Thank you. So anyway, back to what I was saying is just when you make the decision, we're asking you to consider perhaps, even if it's 22 or 23 years, considering how she came clean in the PSI, and it's shown that in the stipulated evidence. She spent 1 year in the county jail. She spent 3 years on full house arrest. We believe that those factors all combined would justify a sentence of 22 to 23 years, and we ask the court to do that. Thank you.
All right, state.
Just briefly, Your Honor, as you always say, I feel the truth is always somewhere in between. We obviously don't have Mr. Jones' side of the story, and we now have Ms. Diaz's 4 years later. I believe it would probably be somewhere in between, Your Honor. And at the end of the day, it doesn't take away all that she tried to do to hide the truth. She had multiple occasions to tell the detectives the truth. She spent hours being interviewed and she still denied the truth. She also had contact with the police at least once, I think maybe twice, between when he was killed and when the body was discovered. And at no time did she say anything. She knew he hadn't been discovered and the police hadn't gone because she went to that house, which she talks about, the fact that she went back to the house and his body was still there and she took the dog. So, Your Honor, 25 is the only real option here.
Okay, and I remember, the steps, and I always reread steps, and part of the stipulations, it says that there were text messages sent that appear to be text messages to make it seem as though the complainant was still alive.
Yes, Your Honor.
Did I read that correctly?
Yes, Your Honor. To multiple friends and family.
All right. Does anybody want to address that part of the stipulations?
No, like I said, at some point it snowballed and she got caught up in that.
All right. Anything else from either side?
No, Your Honor, just a reminder that we do have the family for victim impact on Zoom.
All right. Ms. Diaz, I want you to know when the state makes an offer a cap of 25, always consider the full range, because when people offer a cap of something, so I consider 5 to 25. I don't automatically say, oh, I'm giving this person 25 or 24. I consider the entire range of punishment, okay? And I understand what the defense is asking for. I understand what the state is asking for, and I appreciate both people being reasonable in what they are asking for. All right, as previously stated, the court is finding you guilty. The court will give you credit for any time served. The court will sentence you to 25 years in the prison. And counsel, I see that there were other mentions of maybe potential toxic relationship, abuse, that type of things. I'll request for you the mental health unit or the therapeutic unit, but you'll have to request it as well because I don't have any jurisdiction to force them to put you in specific programs, but that may be of help to you. And your defense counsel will explain more to you about how you could potentially maybe get in those programs. Is there?
Would the court consider granting her credit for the time she was on the monitor?
No. All right. And so we are off the record. My understanding you have victim impact.
Yes, Your Honor.
Do you know I have a Pussy SL112C
No,
and a Teresa?
Teresa for sure. Yeah, Teresa's the
I think other family that you have walked in just to be part of it,
Okay.
but I'm not 100% sure.
but Teresa's the
All right. All right. If you could please unmute. Right. Are you Miss Felix?
Yes, I am.
All right. And are you is she's the person who's going to give impact?
Yes, Your Honor.
All right. Ms. Diaz, victim impact is where family members may talk to you and tell you about how this has impacted their life. Always require that everybody treats everybody with respect, okay?
Yeah.
All right. Ms. Felix, you may begin.
Good morning. First of all, Honorable Judge Boyd, we, the surviving family of Christopher Lee Jones, would like to express our gratitude for the opportunity to give a small measure about how our family has been impacted. I was told we'd only have a few brief moments, and I've narrowed it down to 7-8 minutes, if that is at all possible.
Yes.
I would like to start with the statement from his mother, Leela Peterson. I'm sorry, I'm pretty nervous, obviously. Chris was my firstborn and only son. My hope was that his life would be blessed and anointed by God. That's why I named him Christopher, which is Greek, and Greek means bearer, carrier of Christ, anointed, and that he would always be protected by God. When he was growing up, my family and I tried to provide love and support to him in all he tried to do. Music was always his love and gift. As he ventured on his own, I pray that his name would be a self-fulfilling prophecy for his life. His music was beginning to show how special he was. He was completing his first CD, his tribute to God. Throughout the years he was away from home, we would always keep in touch, and he would tell me about his trials and blessings that led him to writing the songs on his CD. He thought he would finally be able to bless others with his songs. Then evil crept into his life in the disguise of a trusted friend and heartlessly ended his life. All the good memories have, all the good memories have been replaced by sorrow, despair, and disbelief that this could happen. I will never again receive a call from him to let me know he's okay and share with me what has been going on in his life. The cruelest cut of all is the reality that he is gone forever from those of us who loved him, and evil still remains. Next, I would like to share with Mary. Mary, I know you know what Chris is going through with his children, how much he missed them. It had been, about 15 years, I believe, since last time he had seen them. I want to share with you what his daughter, his second daughter, Samira, shared. The day I got the call that my dad had died, my whole world shattered. I felt as if time did not exist. Everything was happening all at once, and I felt as if my life was crashing down on itself, leaving nothing but my broken heart. I remember what happened after we got the phone call. I ran to the washroom and began crying. I kept washing my face because I couldn't believe that my dad had died. It felt like a nightmare, but it was one I could not wake up from and would have to live through for the rest of my life. I stayed in my bed for weeks, heartbroken and motionless. All I could do was replay memories of my dad in my head and look at pictures in our texts because that was all I had left of him. All I could think about is how it could possibly be true. My dad is dead. I kept telling myself and praying to God that he was somewhere on vacation and just forgotten his phone, or he'd just been super tired and was resting. And that was the reason why he wasn't answering his phone. I couldn't believe it. How could this happen? Everything was going so well. It was like every other day I was just talking to him about movies. The last thing my dad said to me was about a movie that he recommended me to watch to help me with my social studies project. Even before we got in the news that my dad had died, I was already in grief. I just knew that he was gone, but a small part of me wanted to hold on to the illusions that I had made in my head. I remember I was in math class and constantly kept checking my phone to see if he had answered the message I had texted him, but still there was no answer. That was when I had my first anxiety panic attack. I got up and left class and went to the library, where I began to cry. A friend of mine came in to me and asked me why I was crying, and I told her, something is wrong with my dad. I couldn't muster up the courage to say I know that he's gone. She told me he's okay and that he's probably sleeping, but I knew my dad. He texted me right back no matter what. It could be early in the morning, and he still replied to my text immediately, as if he wasn't sleeping and was waiting for me to text him back. It was almost as if I was waiting for a ticking time bomb to go off, and there was nothing I could do about it. Our family started to post on his Facebook page to ask where he was and for him to give us a call, but there was no answer. We had then asked my aunt to call the police to do a wellness check, and then we had to wait. I remember coming home after school, and my sister and I knew something was wrong. There was an eerie feeling. Once we got into the house, my maternal grandmother was on the phone with my mom. And though she wasn't on speaker, we could hear her crying through the phone. I've never seen my mom cry like that before, and it pierced through my heart. My grandma put my mom on speaker, and that's when we got the news. It felt as if my heart had cracked and my stomach had dropped. All I could do was go and run into the washroom to cry. The days after my dad had passed away were extremely painful. I would go through our texts and look through his photos on my phone, crying and wishing we had time. wishing that I could just say goodbye and tell him everything I want him to know, like how much I miss him every day, how much I want to hug him, how much I want to see him again, how much I love him, how I'm proud of him after all his adversities, that he's gone through, and how he inspires me to do better and not give up. I wish every day that I could have the chance, a moment, even 5 minutes with my dad, but that will never happen. When I went back to school after weeks upon weeks and still was grieving, my friends were giving their condolences, but it felt as if all their words went into my ears like an empty black hole and disappeared. I was in disbelief, and all I could think about is, how is this even possible? How can I be in a world where my dad isn't here? It didn't make any sense to me. I couldn't believe that the only thing that I had left of my dad were pictures and memories. He was just here. He was just here. So how could he be gone forever? I have a hard time accepting my dad died. I know that eventually everyone passed away, but I thought that my dad would at least have more time before he passed away. I would be there by his side, being there for him and helping him through his final steps. I thought that he would at least be given one more moment before there would be no more moments at all. In fact, I still cannot believe it. I catch myself reading through our text and calling him, crying, hoping he'll pick up, knowing that will never happen. Every time I try to talk about my dad, all I can do is cry. I have problems sleeping because of panic attacks and anxiety. I fear losing my mom and my family. I can't handle it. When my dad died, all I could think about is why? He didn't deserve this. He didn't deserve what happened to him. Nobody does. And nobody's family deserves to go through the pain my family has gone through. This last year, I came to the realization that I'll never see my dad again, speak to him, hug him, and tell him how much I love him, or even spend time with him, because that was all taken away. When my dad died, I cried so much to the point that I couldn't physically cry anymore, and crying became painful. My eyes were burned from the tears, and my throat was so sore till I couldn't speak, and even to drink water was painful. I couldn't. I was in too much pain. I was heartbroken. My dad's death didn't just change my life. It shattered and destroyed it. I became so distressed that my pituitary gland became extremely swollen, and I had to get MRIs. I began to have headaches constantly, and all I could take was medication after medication. I would be sick all the time and could not sleep because of how bad my anxiety and panic attacks had gotten, and I was only 16 at that time. All this is caused by the stress I endured from my father's death. It didn't just shatter my heart and break me on the outside, it broke me on the inside as well. Before my dad passed away, I was getting straight A's in school, but when he died, I couldn't do it anymore. I felt as if studying was a waste of my time. And I realized how short time is. I couldn't waste my time studying if I could spend it with my family, because how would I know if this was the last time with them? I found myself trying to compensate for how I felt about the waste of time I spent studying, when I could have been talking to my dad, when I could have been replying to him, talking to him, instead of telling him, "Dad, can I talk to you later? I'm studying right now." But I'll talk to you later. I love you. One of the worst words, later, because later never came. Later didn't exist for us. I graduated in the class of 2022, and I remember when I was watching my classmates walk the stage, all I could think about is how my dad was so excited to see me and my siblings graduate, but that was taken away from him. And the day that was supposed to be my happiest became my saddest. All I could do was to try not to cry as I heard dads cheer for their daughters as they walked across the stage, on to the next chapter of their lives, knowing that my dad would never be able to do that. Excuse me. For many people, when they lose their parents, it's by old age, and they know they're about to lose them. They are prepared. Family members can say their final goodbye and have closure before they lose their parents, but I was never awarded that. The last thing my dad ever said to me was, "Hey, Samira, what's up, Angel? Did you watch that movie yet?" And I never got to reply. I never got a chance to say I love you. I never got a chance to say goodbye to my dad, because that was taken away from me and my siblings, my family, and the people I love. Dad, I love you so, so, so much. Words can't even express how much I love you. I'm so, so proud of you. I couldn't have asked for a better dad, because even if I did, I would just get you. I wish we had more time, because a few words can't express how I feel. I'm so grateful for you. You made me a better person. You made me realize so many things I didn't know about myself. You inspire me. You are me and I am you. You are my life, my moon, my sun, and my star. Not just my world, but my entire galaxy and universe. You are my existence. Samira Jones. Oh,
say, Teresa?
This is hard. You know, we lost a big piece of our family. Everyone has things in their life that they wish they could change, and things that sometimes happen that they wish didn't happen. But to cover up and do the things that you did, Mary, I mean, you text me from Chris's phone telling me how Chris decided he was going to leave our whole family behind. He was moving to Texas and all this, and just rambling on and on about as if, and then when I tried to call his phone, I'm saying, Chris, why is Mary text me from your phone? Of course, I didn't know what happened. That was so cruel, and just leave him there. Do you realize that when we got his body back here, that was during the pandemic. If he had been discovered a day or two later, we wouldn't have been able to even get him back here because everything shut down almost the day or two after we finally got his body back here. I don't know what else to say. I hope God has mercy on your soul, that you understand what you have caused, you know, whether intentional or not, I don't know. This is cruel. That's all I can say. Thank you, Judge Boyd, for letting me take the time to express our feelings.
All right, thank you. I'm sorry for your loss.
Thank you so
I'm sorry.
much.
No, I'm not.
Oh, that's right.
Yeah,
Sorry.
thank you. I'm sorry for your loss.
Thank you.
All right, thank you.
Deborah Fuqua Frey, David Frey versus Emmanuel Greenwell, 2401112. And Ms. Fuqua Frey, can you please unmute and state your name for the record, please?
Deborah J. Fuqua Frey.
All right, thank you. And Mr. David Frey, your name for the record, please?
David Frey.
Okay, I do apologize to both of you for the delay this morning. I will note that this matter was originally, let me see here. I think there was another date this matter was originally scheduled. Let me see here. Okay, on July 25th, this matter was
Yes, Your Honor.
sent out for July 30th. I'm trying to see if there was a previous date that this had to get moved from here.
The original date was canceled, Your Honor, by the court because due to your absence. And Mr. Greenwell did show for that, tried to show up, but it was canceled. And we did meet with him, and we were trying to get a consent agreement out of him. And I'm assuming he's not present today, correct?
That is correct. He did contact me via email.
Okay. So
I will note that, sir, I will note that this court, it was an unexpected absence, and it was a very late notice, and I do apologize for that. I had a family member that was having surgery that I needed to be there for. And so I do apologize for the late notice of that. The court will also note that I only show Ms. Fuqua Frey's name on the complaint. I don't show Mr. Frey's name. So for right now, sir, I'm going to ask Ms. Fuqua Frey a couple of questions. So I will note Ms. Fuqua Frey, which that is something that I'm going to have to, and if you were to say that really quickly, it's a big tongue twister. However, Mr. Greenwell did email in. He is out of town and he doesn't get very good service. He's stating that he's set to return on the 5th of August. He only received this notice yesterday. And it wasn't mailed out until the 25th. So that would stand to reason. So apparently there was some attempts to have communication. I don't know how that went. And so this is where we're at. He wasn't personally served. There wasn't a second mailing, so I can't enter a judgment today. Okay.
Okay.
I do understand based upon the communication that came into the court that you have tenants that are supposed to be moving in August 1st.
Yeah.
Okay. Well, maybe they can wait a few more days. We can put this
Well,
on.
we've already worked something out with them, but, Your Honor, this guy's always out of town.
Well, here's what I'm going to do. He states he's coming in back into town August 5th. I'm going to set this for August 6th, and I will set it for in person, so then there's no issues regarding any Zoom concerns or any technical issues that would have to be adjourned again. Okay? So
Could you let my husband talk?
Well, he doesn't.
He's the one that's been dealing with them.
Okay, but he's not necessarily a party to the action because his name isn't anywhere on the complaint. I'm only showing that it's your name on the complaint. But I would prefer for us to handle all of this on August 6th. But Mr. Frey, what is it that you would like the court to know?
Thank you, Your Honor. We met with the tenant prior to the last hearing. He did try to show up, even though it was canceled. He's trying to delay as far as him being out of town. He's up in Tawas. He's hardly at the residence. He's evading service. And I spoke to him yesterday. He does have a phone. He has no reason to not be here, present on Zoom. So we would like to make a motion, demand for possession, and then hold over the hearing for damages to the 5th, because he was trying to delay this for 60 days. He's in trouble up in Tawas. He was convicted for domestic violence, and he has a camper up there. He has not been home. I did talk to the process server, and he told me, he was unable to serve him personally. So we're not going to be able to get a money judgment, but I would appreciate if you could give us a possession judgment. There were 2 notices mailed. It should show it in the record with certificate of mailings. And there's no reason to delay the possession at this time. He's totally aware of what's going on. Okay. And he's always in Tawas, and he's in trouble all the time.
Okay, well, sir, so a couple things. Number one, what his dealings are up in Tawas, those may be his dealings. He reached out to the court via email to let the court know that he's returned phone calls and driven to town. He has service, and that he has made those attempts. The statement that there's no reason he can't be on Zoom, if he doesn't have service, then that would be a reason. I don't know how remote where he is located is, I'm not sure. However, I will note as well that there was not a second mailing paid for and done, and there wasn't service. So per the changes in the statutes, I cannot enter a judgment today. So I'm going to only adjourn it for 7 days for the next hearing on August 6th.
Okay. I thought, are you saying that the court didn't do a second mailing, Your Honor, or we didn't?
So there's a procedure. So we mailed out a notice for the second date. But in order for this court to enter a judgment, a default judgment, there would have to be a second mailing paid for by the landlord.
So to pay the court to mail it out again? Because I was told by the court clerk that we had to do our own mailing, and I paid for one at the court. They didn't tell me I had to pay for a second one, but we did 2 mailings, and I provided certificate of mailings.
Well, in any event, I don't see a second mailing.
Okay, I put 2 certificates of mailing in the record. I brought those into the court.
So I'm not suggesting that you didn't submit a certificate showing that you mailed it out. I'm not suggesting that. There's what's called the second mailing. Where,
No, I mailed them, Your Honor. I mailed them twice.
Okay, okay, maybe there's a misunderstanding somewhere. I'm not sure. All I know is that there's nothing in the file, in the computer file, which shows the second mailing was done. I'm not saying specifically it wasn't done or not. I'm just saying right now, I can't see it in the computer. It's not showing that it's in the computer. Nevertheless, Mr.
Greenwell, Your Honor,
contacted the court via email and stated he was out of town. He would be in town on August 5th. So I am going, and that he was not in a great spot. I don't know. I will say that he also stated he was on Zoom until 10:28 the last time before he was informed it was canceled for the one that I had to.
Yes, Your Honor.
A very late notice, which again, I apologize. So we are going to set this for August 6th at 8:45 in the morning.
Okay. Can I ask a question, Your Honor?
Yes.
Okay. I did provide 2 certificates of mailing on that to the court clerk. Should I reach out to her and make sure that that she has it? And if not, then I should send a second mailing.
Well, sir, I will note that our landlord tenant clerk has been out ill last week. So if you want to bring it with you on August 6th, that would be good.
So we don't need to do a second mailing?
No, because I've already set it for August 6th.
Okay. All right. Thank you, Your Honor.
All right, thank you. Have a good day.
You too. Bye.
All right, thank you. All right, let's go off the record.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is absolutely. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go no patience. Trust me, today, I'm sitting up here, I'm the one that needs a drink.